and Mr. Hassan Noura. IBC Revolts is the 16th respondent. Yet another clarification. There is Mr. Milimo Esore for the Speaker of the National Assembly. Ms. Gathera is holding brief for Dr. Kamoto for the 10th respondent. I think finally we have everybody on record. Thank you very much.
On the appearances. We recorded the appearance for the first petitioner, but there are several other petitioners. I don't know whether they are also expected.
Good morning, my lord. Your looks is really weird. Perhaps Jeremiah for the third petitioner. The quorum for the third petitioner is as follows. My learned colleague Christopher Wainaina, my learned colleague Andrew Moge, my learned colleague Bernard Levito, my learned sisters Sasha Wamai and Lillian Wamboya. My lord, I'm also holding brief for the 43rd petitioner, Mr. Morara Omoke. I think it would be easier if everyone just introduce themselves for the rest of the petitioners.
My lord, my name is George Savinka. I do appear together with Mr. Ogada for the 4th to 8th petitioners.
My lords and ladies, please see the matter. My name is Wamboi, Shadrach Wamboi. I appear for the 9th petitioner alongside my learned sister, Ms. Wandera Wanjiko, Mr. Jeff Kanyethe, and we have the honor and privilege of holding brief for our seniors, Mr. Dunstan Omari and Mr. Samson Tabea. Thank you.
Nine petitioners.
May it please you, my lord and my lady. My name is Kibe Mungai. I appear for the 10th to 41st petitioners alongside Mr. Martin Kamwaro and Mr. Peter Poira. We are also assisted by Ms. Sylvia Mosomo and Mr. Charles Napiu.
If it may please your lordships and lordship, my name is Mohan. I do appear for the 58th petition.
May it please you, my boss, my name is Edward Jim. Alongside my right friend, Mr. Wangi Degwa, Mr. Bob Simon, and Mr. Boniface Nyamu, we appear for the 44th, 9th petitioners.
My lords and my lady, my name is Gachagwa. Before I continue, there is a qualification needed. There were files which were given directions together with 565, the ones which were not completed, whether the hearing is proceeding at the same time. I'm asking about 599.
Your file is fine.
599.
That matter is not among the consolidated petitions. I give the directions that once we complete this, it will be mentioned for further directions.
You are most all right. The directions are not being communicated.
Good morning, my lords and ladies. I'm Ms. Awon, following brief for Mr. Musogo for the 7th interested party.
My lords, we have other petitioners, but I don't think they're here for this court. Jeremiah, for the third petitioner, we're requesting for one cumulatively. I will not take it.
Second, so that we know how much. Second, so that we know how much time we like to take for purpose of application.
We had some discussion with majority of plans have indicated they will not be able to take a lot of time that will speak for themselves. The only petition likely to take some time that is from the workload is a petition for the death, the first petition, which we have indicated from the work of the case that we will take. Now having done the submissions and added to the submissions, we will record that we will do 2.5 hours. So I believe the other petitioners can speak for themselves. My understanding is that they are going to take a little bit short. We will not for the fourth meeting of submissions. Was it like you were? My lords and ladies, on behalf of the ninth petitioner, we are here also to submit with the requesting the community can count at approximately 25 minutes. 25 minutes that we share between myself and my colleague, Ms. Rivera, to persuade to allow and use our amazing.
Well, I think you normally don't get exactly what you asked for. So if we can give you half what you have requested, I think that would be a better way to go. Mr. Kibe will give you 1 hour. Thank you very much.
I have to say, yet we went to that. It is simply not possible for us to be absolutely.
But what about 2 hours? You know, we can create more hours in a day. We give you 1.5 hours. I think that's fair. Yeah, within 1.5 hours. Mr. Jiro. You had asked, you had asked for 45 minutes.
1 hour, and I'm amending. Read 1 hour 30 minutes. So the judge is pronounced himself to read 1 hour.
I'll give you 45 minutes. Sorry. Yeah. You had asked for 20, maybe 10 can do.
My lord, you can see that the gentlemen are many today. Let the ladies be had too, my lord. So I seek your indulgence.
Yes.
I'll try to squeeze it to 15.
Okay. Can you set the pace for these people so that if you take 7 minutes, they know that people are saying on time? Can you proceed?
I'll try to do my best, my lord.
Thank you.
My lord, we rely on the amended petition dated 9 October 2024, the notice of motion dated 2nd October 2024, the notice of motion dated 9 October 2024, affidavits sworn on 2nd and 9th October 2024, and the written submissions dated 9th January 2024. My lord, to give a background of the events of 1st October 2024, the Speaker of the National Assembly, by the communication number 046 of 2024, notified the House of a special motion for removal of the then Deputy President, His Excellency Gachagwa. Subsequently, on the same, Honorable Mutuse moved the aforementioned notice of motion, and the Speaker proceeded to give instructions on it, and among the directives was that public participation be conducted across the 47 counties. My lords, my lady, despite the lack of a codified regulations on public participation, there exists express and detailed precedents guiding and providing the threshold for the same. I refer you to paragraph 4 of our submissions. On 2nd October, a notice appeared on the delegation, page 14 and 15, detailing an intended public participation exercise on 4th October 2024 at selective venues. The result of that exercise was a negligible 200,000 responses from, as has been quoted before you, my lord, roughly 52 million people, translating mathematically to 0.384% of the populace. My lords, the purported exercise was challenged in court, resulting to the orders by your brother sitting in Kilgoya, Justice Mungo, on 3rd October 2024. The orders by your brother established a binding legal standard against which all subsequent public participation ought to have been weighed against. The same was served upon the National Assembly. In context, that order was not varied, it was not set aside, it was not appealed at all times material to this petition. The National Assembly, therefore, had a binding duty to comply with the court order by your brother to the letter, as even the House that makes laws is not absolved of obeying them. My lords and ladies, allow me to refer you to paragraph 20 of our submissions and read verbatim in Law Society of Kenya and 3 others versus Inspector General of the Police and 4 others, 2024, KEMC 10633 KLR. The court held that once issued, court orders bound all persons and state organs to whom they apply, and that disobedience of such orders risked reducing courts to impotence and undermining undermining the Constitution. The court further emphasized it is not for any party, be he high or low, weak or mighty, and quite regardless of his status or standing in society, to decide whether or not to obey, to choose which to obey, and which to ignore, or to negotiate the manner of his compliance. My lords, this speaks to the supremacy of the law, so that no man is above it, and that we all are under it. If the National Assembly cannot obey court orders, therefore, what business do ordinary Kenyans have obeying the law? It is imperative to note that despite floated arguments regarding the political nature of impeachment proceedings, the courts have negated such avoidant interpretations of the law. My lords, I refer you further to paragraph 24 of our recent submissions in the matter of Mike Mbovi Sonko versus Clark, Nairobi City Council Assembly, and 11 others, petition 11E008 of 2022, KESC 76 KLR, that the court held, though a political process, impeachment proceedings are sanctioned by the Constitution and the law. Subsequently, the National Assembly should have conducted impeachment proceedings of His Excellency regarding Gachagwa within the confines of the law, not outside. The orders by His Justice Mongo calls upon this bench to determine and weigh three critical issues. One, what is to be deemed as adequate public participation? Question two, what is reasonable notice? And three, what is to be considered as qualitative and quantitative? On the first question, it is apparent that there was orchestrated systematic exclusion in various constituencies, and some of the offices remained closed. This was not accidental, it was intentional, it was planned, it was vitiating the adequacy of the process and its outcome. And this is in regard to paragraph 20 to 30. For adequacy to be applied, prior sensitization and education of the subject matter is necessary. On the contrary, no civic education was conducted. There was no material evidence accompanying the allegations. There was no opportunity provided for the Kenyan people to seek clarification on the issues raised on the form provided by the National Assembly as a template for public participation. This resulted in an obvious information bias, the danger of a single narrative, exhibiting the inadequacy of the process. My lords, my lady, in regard to the second question, I presume, my lords, that reason would have to be extinguished from the word for public gazette that was issued on 5th of October 2024, and subsequently, on the same day, a public participation undertaken for it to be deemed as anything reasonable. My lords, it is the height of blatant contempt dressed as compliance. Courts have ruled that conduct calculated to defeat the purpose of court orders amount to contempt. I refer you to paragraph 31, written submissions in Samuel M. Mweru and others versus National Land Commission, and two others, 2020, KEHC 9233 KLR. The High Court stated that contempt proceedings vindicate the broader public interest in obedience to its orders, since disregard sullies the authority of the courts and detracts from the law. My lords, pertaining question 3, the brother went into the trouble of quoting the Supreme Court in the famous case of BAT. He was very express as in regard to what required to be done pertaining to the public participation, that it left no question whatsoever to what the National Assembly was expected to do. The qualitative and the quantitative aspect of the public participation. My lords, allow me not to quote the BAT case. I know it's already on the records, but I refer to it in regard to this. Would demand, 1, adequate information provided to the Kenyan people, which was not provided in this regard, and sufficiently reasonable notice issued for them to be able to participate, both of which are lacking. It is therefore my submission that on the test of the 3, the purported public participation carried out by the National Assembly falls short of anything that can be deemed qualitative, quantitative, reasonable, and adequate. The National Assembly, my lords, cannot use Order 64.2 of the Standing Orders against constitutional protection of Article 10 and 118 of the Constitution of Kenya. Article 2.4 is expressed as to the supremacy of the Constitution in light of any other law or any other provision that is deemed to be contrary to the same. Allow me to refer you to paragraph 96 of our written submissions. And in specific, the matter in Orange Democratic Movement Party and 4 others as a Speaker of the National Assembly and 5 others, Constitutional Petition E491 of 2023 and E10, E025 of 2024 consolidated, and the rest, Your Honor. Second time. In verbatim, the High Court held standing orders were procedural rules which guided and informed how the National Assembly should, at a minimum, conduct its business, including public participation. Standing orders did not, however, override the Constitution and were not a substitute to constitutional edit or public participation as expounded by the courts. It is therefore clear that should there be any conflict in regard to the standing orders of the National Assembly and the Constitution of Kenya is supreme. My lords, my ancestors are talking to me. My lords, paragraph 97, my lords. In Kenya National Commission on Human Rights versus Attorney General and another, 2015, 7634, the court held that the jurisdiction of the court to invalidate laws that are unconstitutional is in harmony with its duty to be the custodian of the Constitution, which promotes its supremacy at Article 2 by proclaiming at Article 2.4 that any law, including customary law, that is inconsistent with the Constitution is void to the extent of its inconsistency. And any act or omission in contravention of this Constitution is therefore to be deemed invalid. My Lords, Article 150, as read with Article 145 of the Constitution of Kenya, does not expressly limit the time within which a resolution for impeachment must be arrived at or concluded. Standing Order 64-2 therefore lacks constitutional bearing and is subject to judicial review by this esteemed bench. Its constitutionality must be examined under Articles 24, Article 165, 3D of the Constitution that gives this bench the authority and the jurisdiction to interpret the same. My Lords, it is my submission that demonstrably public participation purported to have been carried by the National Assembly is, for want of a better word, a symbolic affair. It was a display of the favorable nature of our attempt at democracy as a nation, and if the apparent manner in which it should have been conducted was clear and loud from Justice Mungo's orders, perhaps then the prevailing circumstances of a premeditated, politically instigated process, it could have fallen, or the orders of Justice Mungo could have fallen on deaf ears. With no shield under Order 64-2, the National Assembly is therefore exposed for what it exhibited as a law-making body that does not obey the law. This must result in an outcome that cannot stand in a constitutional democracy governed by the rule of law. Allow me to refer you to paragraph 33 of our submissions in the matter of Mark Foy versus United Africa Company Limited, 1961, 3 ER 1169. The very famous Lord Denning, who was as classic as the good professor of law, Gideon Muigai, held that if an act is void, then it is a law nullity. It is not only bad, but incurably bad. You cannot put something or nothing and expect it to stay there. It will collapse. Any subsequent actions undertaken by the National Assembly based on the null and void acts of the purported public participation must therefore collapse. They cannot hold in law. Blatant disobedience of the court orders must be rendered null and void ab initio. My lords, my lady, I think I've kept my time. As the Latin maxim goes, fiat justitia duat caelum, and for the benefit of our lay friends, let justice be done though the heavens fall. My lords, I will not proceed beyond that. And the good Senator Agenda was muttering something when I said that I have my sisters, my learned sisters here. Yes, they're my sisters, Senator, but they're not available. Thank you, my Lord. I hand over to my colleague, Mr. Muge.
Thank you. You are smart for the time. We hope that subsequent parties will observe that trend just you said. You asked for